Afternoon and welcome to the Committee on Judiciary. It is Thursday, March 25th, and I would like to call this meeting to order. Will the clerk please take roll call attendance?
Madam Chair.
Here.
Senator Archambault. Senator Reptakis. Senator Burke.
Here.
Senator Oyer.
Here.
Senator Lombardi.
Here.
Senator Quesada.
Here.
Senator Rogers. There are six members present. You have a quorum.
Thank you very much. We have a pretty heavy agenda this evening.
It should be. I got two committee meetings going on right now. I
Before
just wanted to let you know.
we hear a bulk of the bills,
All right.
I would like to,
Yeah, bye-bye.
excuse me, Senator Rogers, could you mute? Thank you. What I'd like to do is take the four bills that are on the agenda for consideration first. The first bill we have for consideration this evening is Bill number 56 by Chair De Palma. And this act would preclude the disability of a parent from serving as the sole basis for denial or restriction in matters involving a child's welfare, foster care, family law, guardianship, and adoption. In addition, this act would prohibit an investigation of possible child abuse or neglect based solely on a parent's disability unless the child is considered to be abused, neglected, or threatened with harm. Do any committee members have any questions or comments? With that, I'd like to entertain a motion for passage of Senate Bill 56. Do I have one?
So moved.
Thank you, Senator Lombardi. May I have a second?
Second.
Thank you, Senator Rogers. Seconded by Senator Rogers. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quesada.
Yes.
Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
Thank you. And Senate Bill 56 passes to the floor. The second bill for consideration this afternoon is Senate Bill number 128 by Senator Reptakis. This act would repeal the requirement of law enforcement officers issue only warnings of the risks to persons leaving a child under the age of 7 unattended in a motor vehicle. Do any committee members have any questions about that bill that we've already heard? Very good. May I have a motion to pass Senate Bill 128?
Motion to pass.
Thank you. May I have it second?
Second. Second.
Thank you, Senator Lombardi. He seconded that. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quesada.
Yes.
Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
Thank you. The vote is 6-0, and Senate Bill 128 passes to the floor. Our third bill up for consideration this evening is mine, and we do have a sub-A on that. May I have a motion to indefinitely postpone Senate Bill 133 and bring forward to the committee Senate Bill 133 sub-A, please?
So moved.
Thank you. Senator Lombardi made that motion, seconded by Senator Oyer. May I have a roll call vote, please?
Madam Chair.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quesada.
Yes.
Senator Rogers. There are 6 in the affirmative and none in the negative.
And the bill is properly before us. So that I could let the committee members know, this act would increase the maximum amount to be recovered in civil court as a small claims from $2,500, and originally it was $7,000. I've had a conversation with the district court. I checked with Chief Judge LaFazia of the district court to be sure that the district court could accommodate the increase in cases that may result from this legislation. And it was decided that it should be raised only to $5,000 instead of $7,000, and that's the reason for the sub-A. So we made that adjustment in that bill. Do I have any questions of any committee members? Okay, very good. If I could please have a motion to pass Senate Bill 133 Sub A, please.
So moved.
Thank you. Senator Oyer made that motion for passage, seconded by?
Second.
Thank you, Senator Burke and Senator Rogers. Mr. Clerk, if you could take a roll call vote, please.
Madam Chair,
Yes.
Senator Burke,
Yes.
Senator Oyer,
Yes.
Senator Lombardi,
Yes.
Senator Quesada, Senator Quesada,
Yes. Yes.
Senator Rogers.
Yes.
There's 6 in the affirmative and none in the negative.
The vote is 6-0, and Senate Bill 133 Sub A passes to the floor. Our last bill up for consideration this evening is Senate Bill number 561 by Senator Coleman. And that act would prohibit discrimination in housing against those persons who have a lawful source of income. Do any committee members have any questions at this time? Seeing none, may I have a motion for passage?
So moved.
Thank you. Senator Oyer moves passage on Senate Bill number 561. May I have a second, please?
Second.
Seconded by Senator Burke. May I have a roll call vote, please?
Madam Chair,
Yes.
Senator Burke.
Keep again. It says another device is running.
I'm sorry?
Senator Archambault, I think, needs to mute your, Madam Chair.
Senator Archambault, would you please mute your... I'm sorry to interrupt the vote. If you could begin again.
So, Madam Chair,
Yes.
Senator Burke,
Yes.
Senator Oyer,
Yes.
Senator Lombardi,
Yes.
Senator Quesada,
Yes.
Senator Rogers.
Yes.
There's 6 in the affirmative and none in the negative.
The vote is 6-0, and Senate Bill 561 passes to the floor. Okay. Next, we have 18 bills scheduled to be heard this evening. In keeping with the existing virtual protocol for this committee, I would ask for a motion to hold all 18 of these bills before us.
So moved.
Thank you, Senator Lombardi made that motion to hold for further study, seconded by Senator Oyer.
Second.
Thank you.
Second.
Mr. Clerk, will you please take a roll call vote?
Madam Chair,
Yes.
Senator Burke,
Yes.
Senator Oyer,
Yes.
Senator Lombardi,
Yes.
Senator Quesada,
Yes.
Senator Rogers.
Yes.
There's 6 in the affirmative and none in the negative.
Thank you very much. In an effort to utilize both the sponsors and public's time more efficiently while conducting these hearings virtually, I will ask each of the sponsors, if present, to introduce and explain their bill. Upon conclusion of the sponsor's introduction and explanation, we will then take public testimony on each of the bills. This way, if a member of the public has signed up to testify on more than one bill, they may do so. Okay, let's see.
Madam Chair.
Yes, Senator
May I
Archambault.
count in the affirmative on prior bills?
Senator
Madam Chair,
Archambault.
Madam Chair, Senator Archambault sounds like he's coming from Dodger Stadium.
Yes, he does. And Senator Archambault, I'm sorry, but you're muted right now. Okay, so you're in twice. When he comes back, I believe he asked to be recorded present and to be recorded in the affirmative on any votes that he missed. Seeing as it doesn't affect the outcome of any of those bills, his request.
Madam President, yes, I think it's worked out. I'm here if I could be counted as present and in the affirmative. We had some problems working the screen out. Thank you.
Very good, all set, Senator. Thank you so much. The first bill on the agenda for hearing is Senate Bill number 518 by Leader McCaffrey. It's an act relating to criminal offenses, general provisions, delineates the definitions of felony, misdemeanor, and petty misdemeanor. The bill is identical to a bill that passed the Senate in 2018, and it was originally a part of the Justice Reinvestment Package. Under current law, there are crimes that are felonies even though they carry no risk of a prison sentence. That is because the statutory definition, any crime that carries with it a fine greater than $1,000 is automatically deemed a felony. This bill amends that statute to say that in order for a crime to be a felony, it must carry a possible prison sentence of more than a year. Does anyone have any questions? Okay, very good. We'll move on to the next one, Senate Bill number 188 from the Attorney General's Department, sponsored by Leader McCaffrey. This is an act relating to Food and Drugs Uniform Controlled Substances Act, amends the Uniform Controlled Substances Act, and reclassifies simple possession of 10 grams or less of certain controlled substances as a misdemeanor punishable as a 2-year misdemeanor rather than a felony. This bill, let's see. Does anyone have any questions of this bill at this time? Okay, we'll move on to the next one, Senate Bill number 65 by Chair Miller. I believe he's online. There you are.
Yep, I'm here.
Hi, Chair Miller. Welcome to the committee. This is Bill number 65, an act relating to Food and Drugs Uniform Controlled Substances Act, offenses and penalties. Would you like to explain your bill?
Yeah, I'll be very brief. It's a 7-page bill, but there's only 2 words, if you go through it, that are highlighted as change on page 2, line 30. It adds buprenorphine and to those drugs that would be accept those to be criminalized, and it decriminalizes buprenorphine, also known as Suboxone, and it's a very effective medical assisted treatment drug used mostly for opioid patients. And what it will do, to be brief, is just direct you to the Department of Health's letter written by Dr. Nicole Alexander Scott in support of the legislation, where she says that Bill number 65 would decriminalize morphine possession. Decriminalizing possession of buprenorphine will save lives by deterring individuals with opioid addictions from using deadlier substances like heroin and fentanyl. Far too many people are still dying of opioid overdose in our small state. In practical application of current policy, taking away someone's buprenorphine without prescription for possession of small amounts and then releasing that person back into the community substantially increases the likelihood that that person will use street opioids and increases their risk of overdose or overdose death. So what's happening in a real-time scenario that I'm sure a lot of people who will testify on this bill will explain is that somebody who's leaning towards potentially stopping, and hasn't, entered formal treatment, will illicitly purchase Suboxone either to treat their withdrawal, and it puts them in a state where they are available for treatment. And it's just, it's a nonsensical policy to arrest somebody for a drug that all it does is treat people or put them into out of withdrawal and into access for treatment. And with that reference to that letter, I'm open to any questions on it.
Thank you, Chair Miller. And I believe we've passed this in the Senate in a prior
Yes,
year.
we have previously.
Yes. Do any committee members have any questions or comments? Okay, seeing none at this time, thank you, Chair Miller, for joining us this evening.
You're welcome. Yeah.
Next is Senate Bill number 503. This is sponsored by Chair Oyer on behalf of the Attorney General's Office, an act relating to criminal procedure, identification, and apprehension of criminals. Chair Oyer.
Thank you, Madam Chair. This legislation is introduced. It's really continuation of the work that the Senate's been doing with regard to justice reinvestment. And what this bill does is it eliminates the $100 fee requirement to process a record expungement, a criminal record expungement. I worked with the Attorney General in January of last year. We did an expungement clinic in my district, and I will tell you that this was actually right before COVID happened, and the crowds of people who showed up trying to access expungement so that they could have opportunities to move forward with their lives was really overwhelming, and showed an outstanding success for the program and the need for expungement. What we found out after that clinic happened was that when people went to court to try to process their expungements, the $100 filing fee that was required per expungement was really cost prohibitive to many people who are just trying to get back on their feet. So this bill is really trying to help make sure that our expungement laws are accessible by folks who maybe don't have the financial means to access it with this $100 filing fee. So, it's a pretty simple bill. I think it builds on a lot of great work that the Senate has been doing in this area, and I'm very pleased to work with the Attorney General on this issue. He's been a great advocate on these matters as well, and I'm happy to answer any questions.
Thank you, Chair Oyer. Any questions of committee members? Yes, Senator Lombardi.
No, I was just adjusting my glasses, Madam Chair, no
Okay.
question.
Thank you. Any other questions or comments? Okay, thank you, Chair Oyer. The next bill is number 193 by myself, an act relating to criminal offenses, theft, embezzlement, false pretenses, and misappropriations. I've been putting this bill in since 2018. Essentially, this act would require that penalties or restitution payments for larceny of campaign account or campaign expenditure reporting violations be deposited into the Rhode Island Crime Victims Compensation Program Fund and not into the candidate's campaign account. It's a bill that is designed to close a campaign finance loophole. Any questions of committee members? Okay, seeing none at this time, we will move to the next bill, which is Senate Bill number 313 by Senator Archambault, an act relating to public property and works, litter control, and recycling. Senator Archambault.
Thank you, Madam Chair. I was actually asked to put this in at the behest of a law enforcement department because in review of the statute 3115-6, it had a loophole in it. If somebody were to litter on your property, you couldn't charge them the way the statute exists. If it's state land, you could. And in the way it's written, and I have to go back and look at the history of the bill, but whenever it was written, the prospect of somebody dumping something on your land, private property, wasn't thought out and incorporated into the bill. So this would allow you to prosecute somebody if they come and dump something on your land. It's a cleanup provision.
Thank you, Senator Archambault. Any questions? Okay, I see none at this time. Thank you. The next bill is Senate Bill number 315 by Senator Quesada, an act relating to criminal procedure, bail, and recognizance. Senator Quesada.
Thank you, Madam Chair. This bill is being in front of this committee for a few times already. I submitted, I believe it was in 2017 or 2019. But what this bill does is give the opportunity to people who make a small crime to not to pay bail. And the reason I put this bill is for many reasons. I've seen people, especially in the community of color, who get arrested for something minor, and they don't have the money, or the family don't have the money to to take them out. And I've seen people losing their jobs because they have to wait even for sometime even a week or more to be in front of a judge. And when somebody loses their job, if they're able to lose their home, is so many things that can happen to this family. And we already have a homeless problem in Rhode Island, And that's the purpose of this bill. It's a very simple, it's not for a big crime. It's only for misdemeanor. I know I don't pronounce it very well, but it's not for anybody who commit a felony crime or anything like that. It's just to give people the opportunity when you don't have the money to put the bail out, to bail those people out, to give them the opportunity to not to put any money down. Thank you, and I will answer any question you may have.
Yes, Senator Rogers. Thank you, Senator Quesada.
Thank you, Chair. Senator, I just got a couple of questions. When somebody is charged with a crime, I believe there's a bondsman that you pay a percentage of the total bond to get bailed out, I believe. So isn't that usually the process to have the fees down? That the bail bondsman would come in and pay most of it, and you're required to be responsible for a small amount while you're out waiting your trial.
It's true. That's correct. But you get some prize, Senator Rogers. What some people don't even have sometimes $200 or $300 to pay.
If I may ask another question, Chair.
Sure.
Yes.
It just seems to me if we, you always have that stance that at some point we've got to get tough on crime. And what kind of concerns me about this is it actually is almost the opposite. I mean, I hate to say it, but if you can't do the crime, if you can't do the time, don't do the crime to a certain extent. And I think that would also include the bail to get out. And I don't want to re-interject, but they're bail bondsmen where you pay a certain percentage, not even near what the actual bond is to get out. So I think I'm not knocking. It just seems like there's already a mechanism in play. And at what point do we say, sorry, no, you don't have to pay anything if you commit an infraction? It doesn't lead for people to start thinking, maybe I shouldn't be doing this because there are consequences. When you remove consequences, you remove the ability for somebody to say, I shouldn't be doing this. So it's almost a free pass. That's just some of my thoughts.
And I respect your thought, but it's not always that way. I'm not talking about if you commit a felony or anything. And sometimes people, when young, they do stupid thing. Does not mean that person is a criminal. It don't have nothing to do that we don't disagree. And I'm sorry if you hear somebody, it's my granddaughter who's around. But it's not have nothing to do with if you committed a crime, yes, I agree with you, you should pay. It's just to saying sometimes people lose their job for something that they don't have the money. And you maybe said, I don't believe that, but it's hard for some people. And I said that because I got called from many parents sometimes. The children was arrested because they had a fight with the girlfriend. They did something stupid and things like that. And they didn't have the money to get those kids out, even $200 or $300. And they're afraid to lose their job. And I see many consequences happen because somebody didn't have the bail money to be out. You sometimes have to be on those people's feet to be able to understand it. I know it's hard for you maybe to believe that, but I see in it. I heard it, especially the district that I represent. And I don't think these people it's putting anybody in danger. It's not I don't think if they let these people go, they're going to be danger anybody outside.
Any further questions of committee members? Okay, thank you. Senator Quesada, you have another one up, Senate Bill number 408, an act relating to businesses and professions, hotels.
Yes, this is a new bill. I never put this bill before. It was a request from the House, from one of my colleagues. It was already heard in the House, and I heard it has a lot of the hotel owner supporting this legislation. It's about if you see something, say something. If you see somebody bringing somebody to the hotel, if you look, that person is crying or those, I don't know, to report it. We don't want anybody who work in the hotel to be a police or to do anything like that. It's just you see sometimes body language or somebody can say many things. And it's to prevent human trafficking. That's the purpose of this bill. And we just hope, that, and like I said, it was already heard in the House, and it has so many people who work and owner a hotel who support this legislation at this time. And like I said, if you see something, report it.
Yes, Senator Rogers.
Chair, I do own a hotel and a motel, so I do see a lot of this that happens, but my concern is on the business end of it. How do we, and anybody in their good conscience, and even when I'm operating, when things like this arise, I do take the opportunity to make the proper authorities aware. Now, this requires all hotels to make a good faith. I think we're already doing that, and at what point, how would you enforce somebody, because it says requires, where do you draw the line with your opinion that was a good faith that should have been enacted by somebody who owns a motel, where maybe they didn't notice it, but where, I mean, it's almost like it says requires, so when I see requires, I see an opportunity for a motel owner to be sued for not seeing something that somebody else thought he should have saw. In the words, requires all hotels to make a good faith effort to post and make things aware. Concerns me on a off balance of being possibly sued for no fault of their own, which is a cost of the business. It just requires, and how do you enforce and regulate that? And that's in the court system. So that was my only concern. And I am a motel owner, so I deal with this quite a bit. That's all I had.
And I do understand, and that makes sense, that comment that you're just making. I will look into it. And it's true. I don't think it should be a requirement. We were just asking people to, if you see something, said something, because sometimes people notice things and they stay quiet. They don't say anything. I will talk to the person, because this is, like I said, I just put it on behalf of a colleague from the House. I would talk to her and see what other word we can use, especially about not requiring, because it's true. Sometimes you see something, sometimes you notice. Not everybody have the same thing to say, well, she look upset, or she looks sad, or she, and I agree with you on that, 100%.
Thank you. Yes, Senator Rogers.
Just one other point. Also, thank you, Chair. Thinking in my mind, and then when you get to the point where business owners are so scared of, say, somebody got in litigation on it, and it sets an example, then it comes to the point where the pendulum switch. Now all the motel owners are constantly calling, I would assume, the authorities to investigate this, a well-being call or questions. And many times when somebody may show up crying, you just use that for an example. This will tie up police officers just because the hotel may be just trying to cover this situation and not be forced into a litigation issue that they may have seen happen. Just, you don't have to respond. That was just an addition to when it goes the other way. So, thank you.
Thank you.
Thank you, Senator Rogers and Senator Quesada. Do we have any other questions or comments from committee members? Okay, seeing none at this time. Senator Rogers, you may continue. I believe you have Senate Bill number 530, an act relating to criminal offenses, burglary and breaking and entering. You're on mute.
Wait, my paperwork out here. Yes, these are two bills that I introduced. They're somewhat in tandem. One relates to basically a lot of people may refer to these as castle laws. Many of you heard castle laws in other states. This specifically relates to whether the first 530 is if you're in a vehicle. It's for the sake of an argument, a castle law where if you feel a person adds rebuttal defense, if any person shall die or sustain a personal injury while committing a robbery of the owner, lessee, or occupant of a motor vehicle, that the owner and occupant of the vehicle acted in self-defense. So there is some things I wanted to underline. Shall refutably be presumed as a matter of law in the civil or criminal proceedings that the owner, tenant, occupier, or place where that violent offense committed, a reasonable act of self-defense, that might have been the other bill, but both of them stand in tandem. It's kind of helping the people that may be victims out, that if they don't have a duty to get away to the point where they can defend themselves if they feel like their life is in danger and imminent death or injury. So that's kind of a nutshell on them. And the other one pertains to the household, where this one pertains to a motor vehicle.
So 530
Motor vehicle.
530 is motor vehicle, 533 is an act relating to criminal offenses, burglary, breaking and entering, and has to deal with a home. Is that what you said?
That is, or if you're a tenant in a house,
Okay.
and you're a renter, and you have a legal right to be there for any reason, and you feel somebody is going to bodily harm or death or serious injury, you have a right to, if you defend yourself in any manner, and that person dies, it gives you a little bit of self-defense.
Any questions from committee members? Okay, seeing none at this time. Thank you, Senator Rogers.
Thank you.
Next bill is Senate Bill number 249 by Senator Bell, an act relating to criminal offenses, sexual assault. Senator Bell, welcome.
Thank you so much, Madam Chairwoman. What this legislation does is it makes it illegal for members of law enforcement to have sex with people in their custody. There's a movement around the country to make this illegal, and bills have been introduced and passed in a number of states. This legislation would apply a 3-year prison term, up to 3 years, similar to legislation enacted in Maryland. With that, I'd be happy to take any questions.
Any questions of Senator Bell? Seeing none at this time. Senator Bell, you have the next one also, which is Senate Bill number 257, an act relating to criminal offenses, theft, embezzlement, false pretenses, and misappropriation. Senator Bell.
Thank you so much. So what this legislation does is it addresses an issue in the sentencing structure for low-dollar theft and shoplifting. Currently, there's no minimum dollar value for incarceration for shoplifting and theft. And so you can go to jail in Rhode Island for stealing a candy bar. And because there are mandatory minimum triggers in the law, that can actually be required in some cases. So what this legislation would do is create a tiered sentencing scheme only for the low dollar thefts, and it would phase into the currently existing sentencing scheme for higher dollar thefts. At the lowest dollar level, it would be only community service, and then it would phase in with lengthening prison sentences with increasing as the value of the amount stolen increases. It also abolishes the mandatory minimum triggers for habitual offenses and seniors. I'd be happy to take any questions about the legislation.
Any questions for Senator Bell? Yes, Senator Archambault.
Yes, thank you. Senator Bell, I can tell you from having spent the majority of my career prosecuting these cases and defending them routinely, sometimes in the same day, that there is a flexibility built into the system in the discretion that will happen in discussions between prosecutors, judges, and defense attorneys. So I like the spirit of what you're doing. I have one concern, and I'm not sure it's enough to countervail the bill, and that is that sometimes there's always three things that I look at, and I kind of break it down to this paradigm when I'm talking to clients or prosecuting. There's three things that really get looked at when you're in the criminal system. There's the criminal record or lack thereof. There are the charges on the other hand. And then there are the facts. And that facts are like a sort of ball in the middle. Prosecutors will argue aggravating facts. Defense attorneys will argue mitigating facts. And those three things are always in flux. What just sort of jogs my mind is the prospect that some of these, one of the tenets in here calls for there to be, community service, depending on what's stolen and the dollar value. But what if the person has a horrible criminal record? I open the folder and I see larcenies going back, from the beginning of time. Your heart's in the right place on this. I wonder what you would think about that. And it's just a concern. It's something that I think may have to be addressed. And I'm all for lowering the amounts so that we give people an opportunity to get on the right path. And just so you know, and I'll end with this, if somebody comes in with a first offense, shoplifting, and there's no criminal record, I'll offer them community service, maybe a very small monetary contribution if they can afford it. And then sometimes I'll ask them to write a letter of apology. I'm not looking for the personal letter of apology. I'm hoping that is something with the court's eyes that helps them to look inside, be introspective, and heal themselves. You'd be amazed at what comes out of the letters. Oh my God, I'm so sorry. I had these circumstances. My life is so much better now. So they're very therapeutic, but I'm a layman. I have no clinical skills here. But so keep that in mind. And I just wonder what you think about that in terms of the lowest marks on where you're going with this.
Yeah, so I definitely agree with that principle. I think that when you have repeated offenses, I think that you should face more stringent sentences, and that's built into the bill. So on subsequent offenses, the dollar level for where an incarceration begins as a penalty drops to $25. And so that was the idea, was to build in stricter penalties when there are subsequent offenses. And so the length of the prison terms in certain cases in the formula will actually increase with a second offense and increase further with a third offense. I would be happy to talk about restructuring the details of how that works, but I certainly agree with the overall principle that the more offenses you have, the more the longer the term should be. But I don't think we should ever get to a point where you are forced to have a mandatory minimum, even for very low dollar thefts.
Yeah, Madam Chair, if I may respond, and I think you're on to something there, because many years ago, a law school professor I had, David Zlotnick, he was a federal prosecutor at one point, he wrote a treatise on how the mandatory sentencing benchmarks in federal court were all misplaced because people fall into these categories and their lives are over just because they're in this mandatory sentencing. So I get where you're going. So I'd like to talk to you more about it. We don't need to digress here, but it's the dollar value. You could have somebody who's a repeated offender and then they get hit with $25, and there may not be a deterrent effect in there. It's all that healing the people that can be healed. Some people, I want to keep an open mind. When you see records going back 40 years and, they'll look you in the face and tell you, oh yeah, thank you very much. And go right out the next day and commit a theft, and I get the case again. It's crazy. So there has to be some balancing test, But I like the spirit of what you're doing. Thank you.
Well, thank you so much, Senator Archambault.
Thank you, Senators. Any other questions for Senator Bell? Seeing none, thank you very much for joining us this evening, Senator Bell. Next, we have Senate Bill number 189 by Senator DeMario, an act relating to labor and labor relations, fair employment practices. Good evening. Welcome, Senator DeMario. You may proceed.
Thank you so much, Chairwoman Coyne. So this bill would prohibit employers from requiring a non-disclosure or non-disparagement agreement regarding alleged violations of civil rights or criminal conduct as a condition of employment. So S-189 is really based on the simple belief that workers should be safe at their jobs and that signing over your civil rights should not be a precondition to employment. This bill has been introduced before in the past by Senator Oyer, and I appreciate her letting me take this on. The reality is that people need their jobs. They need their jobs to pay their bills. They need their jobs to keep their health insurance. And a lot of power rests in the hands of employers already because of that reality. And so when an employer sets the expectation from the moment of hire that a person's livelihood is potentially on the line if they speak up about sexual harassment, racism, homophobia, or other abuses, it then creates a workplace culture where bad behavior can thrive and where workers are further disempowered. people recognize that secrecy perpetuates harmful behavior in the workplace, which was reflected by a recent national poll that shows 80% are in support for ending secrecy around sexual harassment and other misconduct at work. And in addition, it's important to know that 16 other states have banned non-disclosure agreements and or non-disparagement agreements as a condition of employment. Further, I do just want to tie this to the fact that, the Senate did just pass the Dignity at Work Act because we recognize the mental and physical toll that toxic and bullying workplace behavior has on workers. And so this bill would be a preventative measure to help support that goal of a safe workplace environment. Again, as I mentioned, this bill has been introduced in the past and has been supported by the ACLU, the Rhode Island National Organization for Women, the Economic Progress Institute, the Center for Justice, and many other pro-worker organizations. And I also do just want to note that, this bill would not prevent an employer from requiring any type of agreement that would keep trade secrets confidential or, anything regarding secrecy around business practices. It simply just addresses that issue of not requiring the non-disclosure or non-disparagement agreement around alleged civil rights violations or criminal behavior. If anybody has any questions, I would be happy to answer them.
Thank you very much, Senator. Any questions? Yes, Senator Archambault.
Just a quick comment. This is an excellent bill for all the reasons that you just put forth. This is an excellent bill. I like this bill. Last time I saw it, I'm glad it's out there and this should be passed. Thank you.
Thank you, Senator Archambault. Any other questions or comments? Yes, Senator Oyer.
I just wanted to thank Senator DeMario for picking this up. I do also agree that this is a really important bill. And I think one of the things that's important about the way that this bill is framed compared to some considerations that have come up when this bill's been heard previously, there was a concern raised that the legislation would prohibit a blanket prohibition on a non-disclosure agreement. And as many as the attorneys know, the many businesses will require their employees to enter into a non-disclosure agreement because, many people will have access to trade secrets and other confidential information during the course of their employment. And I think the important part about the way that this bill is crafted is that it's not intended to prohibit those broader non-disclosure protections that people enter into as a course of business, but merely stating that those non-disclosure agreements are not going to prohibit somebody from accessing their claims to having a safe workplace and to be free from harassment. So I want to really thank Senator DeMario for picking up the ball and running with it on this bill, because I do think it's an important piece of legislation. I mean, I know the Me Too hashtag has fallen out of fad a few years down the road, but I think it's still a critically important issue for us to take up. So thank you.
Thank you, Senator Oyer. Any other questions or comments by committee members? Thank you, Senator DeMario, for joining us this evening. Next up, we have Senate Bill number 502 by Senator Burke, an act relating to criminal offenses children. Senator Burke.
Thank you, Madam Chair. This bill is from the Brown State Police Computer Crimes Unit, and it's been in the House already. And Lieutenant Eric Yell will be testifying on it later tonight, and he can give you a better overview of it. It's a bill that makes it a misdemeanor to possess, transfer, or produce child pornography for the purpose of sexual gratification or sexual arousal. And if you have any questions.
Thank you.
Wait until...
I'm sorry, Senator Burke, you were cut out?
No, you can wait until Eric testifies. He can give a better overview.
Okay, very good. Yes, we have Lieutenant Eric Yell joining us later on for some more specifics related to that bill. Thank you, Senator Burke. Next up, we have Senator Acosta for Senate Bill number 393, an act relating to education, criminal background checks of volunteers and interns. Welcome, Senator Acosta. You may proceed.
Thank you, Madam Chair, and thank you, members of the Judiciary Committee. This bill, Senate Bill 393, is a companion bill to House Bill HB 5748, sponsored by Rep. Giraldo. And what we're hoping to accomplish with this bill is remove some of the barriers to entry for folks who want to volunteer. at their kids or nephew or nieces or grandkids' school. So right now, there's a lot of schools who already have the practice of requiring a background check in order to join on a field trip or volunteer on campus. And what we want to do is make it so that the institution would cover the fee for the background check rather than asking that the person who's already volunteering their time and giving their labor would be required to pay. The other part of this, and it's on the second part of the bill, is that if someone were applying for a job that had a wage under or a salary under $40,000 a year, then that job would have to pay for the background check rather than ask the employee. And this was somewhat connected to schools as well, because here we had folks like crossing guards in mind, who may be a big asset to the local school community, but who might not have the disposable income to pay for these. Now, I will concede up front that we want to work on the bill because right now it would require both a state and a national background check, and we want to change that to say or. I did speak to some representatives from local universities who have volunteers and students that come from other parts of the country, where a local background check or a state background check, frankly, wouldn't tell us much information about those folks. And so it makes sense to sometimes use a national one in lieu of a state one. But for folks who are more state-based, I think a state background check would suffice. All that to say, we don't want to make it onerous and require both. And so trying to tweak the language to say or, but happy to answer any questions.
Thank you, Senator. Any questions or comments for Senator Acosta? Okay, very good. Seeing none at this time, thank you for joining us this evening. Next is Senate Bill number 604, Senator Mack, an act relating to Food and Drugs Uniform Controlled Substances Act. Welcome, Senator Mack. You may proceed.
Madam Chair,
Thank you.
Excuse me?
I'm sorry, Madam Chair, we may have skipped 118.
Senator Acosta has another bill.
Oh, thank you. I'm sorry, Senator Acosta. Thank you very much for bringing that to my attention. This is an act relating to criminal offenses, general provisions. Senator Acosta, and my apologies.
Yeah, no, that's fine, and thank you all for noticing that. So this bill is also a companion bill, in this case to House Bill 5488, sponsored by Rep. Felix and 4 other folks on that side of the chamber. It also comes with broad support from the ACLU and several of my colleagues. I have 7 co-sponsors on this bill. What this would do is slightly tweak the misdemeanor sentence to go from a maximum of 365 days to 364 days. This would have us join other states, including California, Washington, Nevada, and most recently New York. I want to point out that it does not take away the ability for a judge or prosecutor to charge defendants. It simply closes a loophole in federal immigration law, because right now a sentence up to 365 days and more classifies this as a deportable offense. To quote the immigration law language, what it says is a crime involving moral turpitude for which a sentence of a year or longer may be imposed could trigger an automatic deportation proceeding. So this law, the way it's written at the federal level, is clearly aimed at felony crimes and those that are serious enough to trigger a deportation. So because our current law for misdemeanors in Rhode Island is punishable by a maximum of 365 days, there's an unintended 1-day overlap in the statutes, meaning that even a first-time misdemeanor offense where no jail time was actually given could trigger a deportation. And so this simple fix would address that issue, and I'd be happy to answer any questions from my colleagues.
Thank you, Senator. Any questions? Yes, Senator Archambault.
Yeah, thank you. And I was reading it, Senator Costa, and I knew that was your intent because I additional prosecutor and I do criminal defense. So I was still a cop with about 30 seconds experience when I had a felony case, and it was in front of Judge Indeglia, who's now retired from the Supreme Court. And I really didn't know what I was doing, but I had a lot of people I could ask, and I had the courage, right? And I had this guy who was he didn't have legal status, and he committed a crime, an assault. It was a bad assault, but I didn't think he needed to be deported. And there was a repatriation act with Cambodia. This guy was going back to a place where there was a hole in the ground. That was where he would go to the bathroom. He died there. Couldn't even speak Cambodian. And I argued to get 364 days, and I was actually able to persuade 2 judges to give me that sentence because he was a violator in courtroom 9-2. And then the prosecutor, who I won't name, who's now a friend of mine, he wouldn't do it. And I tried tooth and nail. And so this really, I think, respectfully, it's not that it closes a loophole, it opens a loophole in a good way. I think it's a positive thing when you can structure a plea that is 364 days and help somebody to avoid mandatory deportation federally, because we're really still getting our pound of flesh here. I don't think anyone can argue that somebody's being let off by this sentence. It just builds a flexibility into the system. I like it. I wish I thought about it. I like the fact that the bill's there. And I don't think it's going to create any new doorway that is unjust if it were to be passed. And I will say this, just to add this, immigration is a very complex area of law. People don't dabble in immigration. When you see an immigration attorney, you go to somebody who handles immigration all the time so that they're able to know weekly the changes in the law. In fact, I'll have people that come in for different cases that have to, the defense attorneys are representing that have to have continuances just so they can get updates on the way their felony cases are impacted by the misdemeanor case and whether or not they are potentially deportable. So, and there are no easy answers. So this would help to at least not see someone be deported because of a felony. It's just say hypothetically a felony drug case that they're trying to work out or work on. There could be a host of reasons. And, they'd still be able to get on the right path in the state of Rhode Island. And as you said, a lot of other states have this. I'm aware of that. There's a lot of states that actually have this. I don't know if you know the number, but there are a lot. So it's a good bill, and I appreciate it. I thought I'd share that with you.
Thank you, Senator. Much appreciated.
Thank you, Senators. Any other questions or comments on this bill? Thank you, Senator Acosta.
Thank you, Madam Chair.
Okay, Senator Mack, you're up next with Senate Bill number 604, an act relating to Food and Drugs Uniform Controlled Substances Act. You may proceed.
Yes. Thank you, Chair. And the goal of this bill is to remove criminal charges from narcotic and opioid possession and in place have civil violations, drug counseling programs, and community service. One of the reasons why is because decades of empirical evidence from around the world has shown that reducing and eliminating criminal penalties for drug possession does not increase rates of drug use or crime, but it also has a drastic effect in reducing addiction, overdose, and HIV/AIDS. Today, as overdose deaths skyrocket all over the U.S., people are in need of drug treatment. They might avoid this treatment because of the criminalization associated with their drug use. But when we decriminalize, we find that people are more likely to come out of the shadows and seek help. Another reason is that criminalizing drugs often hurts families and communities. Many folks will lose job time, or a criminal record will prevent job security, housing, and opportunities for a lifetime, often across multiple generations. And this measure has been enacted in Portugal as early as 2001, and just recently in February, Oregon took this much necessary step. In Portugal, the experience demonstrates that ending drug criminalization alongside serious investments in treatment and harm reduction services can significantly improve public safety and health. And finally, leading public health officials across the entire nation and several other organizations are really calling for a decriminalization of drug use and for public health measures and other triage programs to be prioritized over criminalization. And with that, I will look forward to any questions. Thank you.
Thank you, Senator Mack. Any questions or comments on this bill? Okay, seeing none, thank you so much for joining us this evening. Next, we have Senate Bill number 605 by Chair Oyer, an act relating to labor and labor relations, the Fair Chance Employment Act. Senator Oyer.
Thank you. This legislation, as you mentioned, the fair. Excuse me. Hang on. Let me get my notes. Yep. As you mentioned, this bill is the Fair Chance Employment Act. This bill is prohibiting employers from conducting a background check until after a conditional employment offer is made, and prohibits considering convictions that are more than 7 years old. really what this bill is intended to do, it's actually building upon some of the work that the Senate has done. Specifically, a few years ago, there was the conversation around ban the box legislation, which did pass the General Assembly a number of years ago before I was here. And but since that legislation prevented employers from asking about conviction history on a job application, what's happened since that bill has passed is that now employers have moved to asking for a background check. And the issue with this is really the same as when there was prior to ban the box legislation, which is that, folks just want to be able to get a fair shot at getting a job. They want them to be able to get back into the economy, back into the labor market, move on with their lives. And unfortunately, if history of conviction is brought up early in the employment process, then they don't have that fair chance. They don't have the ability to share with the employer what their skills are and how their qualifications for the job. So this is really a bill about making sure that people have a second chance and a chance to get back engaged, get back into the labor market, provide for their families, provide for themselves, and also, as an important note too, it's been shown through numerous studies that when people have access to employment and job opportunities, their likelihood of reoffending goes down. So, bills like this and being able to give folks a chance to get into the labor market are critically important. I believe we have people signed up to testify on this legislation who will also share their personal experience and their personal history. I do think it's important to note that this isn't a ban on requesting background checks, but it is setting them later in the process so that people have a chance to access these employment opportunities, and that employers can make those decisions, based on a fuller understanding of who the person is employing, and be able to put those, historic convictions in context with who the person is in front of them today applying for the job. So I'm happy to answer any questions on this legislation, and thank you.
Thank you, Senator Oyer. Any questions or comments by committee members? Okay, seeing none at this time. Thank you, Senator Oyer. Next, we'll begin the public testimony portion of the agenda this evening. And we will, I believe Senator Reptakis is he on? Yes, Senator Reptakis. Are you with us? No. Okay. So next is the public testimony portion of the agenda. We'll revert back to Senate Bill number 518 by Leader McCaffrey, an act relating to criminal offenses, general provisions. I believe we have Stephen Brown of the ACLU of Rhode Island. Welcome, Mr. Brown. You're going to testify on a number of bills on the agenda this evening. The first is 518. If you could please let us know what bills you're testifying on when you make comments.
Thank you very much, Chair, and thank you, members of the committee. Stephen Brown on behalf of the ACLU of Rhode Island. I do have a number of bills to go through. I'll try to go through them as quickly as possible. And I'd also encourage members to read written testimony. We've submitted written testimony on all these bills that will provide more detail. The first bill is 518 by Leader McCaffrey. You explained it very well at the very beginning of this hearing. It would fix an anomaly in the state laws that make crimes that only carry financial penalties felonies. And we're hopeful that, as you've done for a number of years, the Senate will correct this anomaly. It was part of the Justice Reinvestment Package. It died in the House, and we hope you'll pass it again this year, and hopefully it will fare better in the House. The second bill is S503 by Senator Oyer, dealing with expungement of criminal records, and particularly we want to express our strong support for the provision that would eliminate the $100 fee to expunge records. As Senator Oyer noted, There are people who go through this process, get to this final point of being able to get the record expunged and all it means in terms of being better chances for employment, housing, and so forth. And then they run into this financial barrier of not being able to afford to get it expunged, even though they meet all the qualifications. So we're really hopeful that this year the Senate will act favorably and get rid of that $100 fee. The next bill is Senate Bill 313. That's Senator Archambault's bill dealing with littering. And we certainly don't disagree with the goal of this bill, which is to ban people from littering on other people's property. We do have a particular concern and urge an amendment to it. Litter is defined in the statute, among many other things, as including paper. And if taken literally, a mischievous government official could charge somebody with littering if, for example, somebody put political literature on somebody's door or their doorstep. That could theoretically constitute littering. So we would urge that there be some language put in that would exempt what we would consider First Amendment activity, protected literature being dropped off on private property. The next bill is S-408 by Senator Quesada, and that's the hotel bill. The bill really has two provisions. One we have no problem with. The second one we do have concerns about. First, it does require posting of signage, human trafficking awareness training for hotel employees, which we think is appropriate. Our concern, though, is about the second part of the bill that has been talked about by Senator Rogers about this reporting requirement. And to be honest, we don't think that hotel employees should be in the business of trying to decide whether a person is or is not a victim of human trafficking. Police cannot do that. I mean, there have been many raids over the years where police have initially said, we've broken up a human trafficking ring, and in fact, there's no human trafficking. And for a very prominent example from last year, the raid that got Patriots owner Robert Kraft arrested was touted as breaking up a trafficking, and in fact, at the end of the day, there were no trafficking charges. So we're just very concerned about having hotel employees interfere themselves, trying to figure out what is and isn't human trafficking, and we would urge that the bill be amended to prevent what we think are potentially dangerous consequences, not just liability for the hotel owners, but because they haven't reported something, but the problems that arise if they do report something erroneously, and a poor couple ends up being interrogated by police. The next bill that we support is S-189. That's Senator DeMario's bill dealing with non-disclosure agreements in employment. It was explained very well. The problem with these non-disclosure agreements in civil rights matters is that what they do is they essentially encourage employers to be able to continue with civil rights violations, whether it's sexual harassment, other types of discrimination, because nobody knows that it's actually a pattern that's been going on, because individuals who've left the employment are not able to say anything. So we think as a fundamental matter of fairness, these types of non-disclosure agreements about civil rights matters should be prohibited. The next bill is Senate Bill 393, which is Senator Acosta's bill dealing with criminal record checks for volunteers and interns at schools. Senator Acosta briefly hit on one of the concerns we have about this bill. We certainly support the effort to get rid of the fees that volunteers and interns have to pay in order to have a criminal record check. We are very concerned, however, both that it, as he indicated, as it's worded, it would authorize or require national criminal record checks, which is much more onerous. It requires fingerprinting. It would be a way of discouraging lots of immigrants, particularly undocumented immigrants with citizen children going to school, from being able to volunteer at their school. And we all know that parental involvement in school activities is really helpful. We're concerned about that. And we're also very concerned about what would constitute the disqualifying offenses under this bill. About 8 or 9 years ago, we had to file a lawsuit on behalf of a parent who was heavily involved in her PTO, who was barred from volunteering at her child's school because she had a past felony drug offense on her record. And again, we think it's in nobody's best interest to bar concerned, passionate parents from being able to volunteer at their children's schools. So for that reason, we oppose the breadth and the scope of Senator Acosta's bill. Senate Bill 118, you'll actually be hearing from an attorney about this in more detail. This is a 364-day misdemeanor bill. I just wanted to mention that this bill also has the support of the Immigrant Coalition, which is a coalition composed of over 24 organizations in the state that promote immigrants' rights. And then finally, last but not least, is Senate Bill 605, which is Senator Oyer's bill that she just finished explaining, the Fair Chance Employment Act. It really is, it's not only going after ban the box, following what's in ban the box, but also what the legislature did just last year, which was the Fair Chance Licensing Bill, which limits the use of criminal records in occupational licensing by the state. We strongly support this bill in concept. We do think it needs some work. We're concerned that a lot of the enforcement involves the Department of Labor and Training. We're not sure they have the resources to be able to handle it. We also note that the bill, as defined, the bill does not cover any government employers. We're not sure why that exemption is in there, but as I said, we strongly support the concept. So with that very lengthy review of bills, I'll be happy to answer any questions.
Thank you, Mr. Brown. Although it was lengthy, it was very organized and detailed, and I appreciate that. Any questions for Mr. Brown? Seeing none at this time, thank you very much for joining us this evening and for your testimony.
Thank you.
Next, we're going to move to Senate Bill 188, the Attorney General's bill having to do with an act relating to Food and Drugs Uniform Controlled Substance Act. It amends the Uniform Controlled Substances Act and reclassifies simple possession of 10 grams or less of certain controlled substances as a misdemeanor, punishable as a 2-year misdemeanor rather than a felony. First up, I believe we have Haley McKee from Super PAC. Are you there?
Yes, I am.
Hi, welcome to the committee. Could you please state the organization that you're representing?
Sure. So good evening, Chairwoman Coyne and honorable members of the committee. My name is Haley McKee. I am here as co-chair of the Substance Use Policy, Education, and Recovery PAC. And I'm here in support of the spirit of defelonization. It's an issue that we've been working on for some time now. We're grateful for Leader McCaffrey's taking on this issue and for the Attorney General supporting it. We do have concerns over the weight limit that's in the current version. When it was introduced in 2 sessions ago, we felt as though the 28-gram threshold was more appropriate, that it would impact a larger percentage of the population. In fact, according to data from Rhode Island, 40% of the active use population who are arrested for simple drug possession come in at over 10 grams. So if we were to lower it and keep this at 10 grams and it should pass, we are really limiting the amount of people who are able to really actually just participate in society, whether they're able to access employment or housing or education. So that, again, we're here in spirit, in support of the bill in spirit. We do think that there needs to be significant improvements on the weight and that it needs to come in at 28 grams. And thank you for your time.
Are you also testifying on Senate Bill 65 and 604?
Yes.
Are there any questions of committee members of Ms. McKee on Senate Bill 188? Seeing none at this time, you may continue your testimony on Senate Bill 65.
That's the buprenorphine bill?
Yes.
I believe. So we're in strong support of the decriminalization of the buprenorphine bill, and we really appreciate Senator Miller's leadership on this issue. I'm a person in long-term recovery from substance use disorder and opioids, and there was a period of time where I accessed buprenorphine for myself through the I guess what you'd call the normal channels, through a doctor's office. And additionally, at other times, I would go through the illicit market to obtain that medication. And all I can say about that is whatever days I was accessing that life-saving medication were days that I did not pass away from overdose from other substances that I was using. And I come into contact with people all the time who I work with. I work at a clinic now, and I meet people who have been arrested for felonious possession of buprenorphine, who have obtained it from the streets, and that really it's a predictor for a worse outcome for their recovery, for their opportunities thereafter. And additionally, I've also met quite a handful of people who have been arrested for their own buprenorphine medications. So these are legitimate patients who have these medications on them. The issue with this medication is that it comes in a prepackaged sublingual strip, and they're individual. So when these people are given a box or two of this Suboxone, they don't tote around the box with them at all times. So these single doses don't have any identifying information on them. So I've met a lot of people who have gotten arrested for medically assisted recovery medications, which is just, it's very sad. So we're here in support of decriminalizing that medication.
And then finally, you have Senate Bill 604 by Senator Mack.
The Super PAC supports that bill for all the reasons that Senator Mack stated. And thank you very much.
Do any committee members have any questions of Ms. McKee? Seeing none at this time, thank you very much for joining us this evening.
Thank you very much. Thank you, Senator. Good night.
Good night. Our next witness is Adi Goldstein from the Attorney General's Office to speak on 188. Welcome, Ms. Goldstein. You are on.
Good afternoon, Chairwoman Coyne. Thank you very much for inviting me to testify this afternoon. I would like to thank all the members of the committee, and I would also like to thank Leader McCaffrey and all of the senators who introduced Senate Bill 188 on our behalf. We're here to talk today about proposed legislation that changes how the criminal justice system addresses one of our most significant public health crises, drug addiction, and removes a significant obstacle to long-term recovery for those who possess drugs solely for their own use, a felony arrest or conviction. How rare is it that the Attorney General's Office, the Public Defender's Office, and the Chief Law Enforcement Officer of our capital city all agree on the merits of a particular bill? Under existing Rhode Island law, simple possession for personal use of less than an ounce of a drug other than marijuana remains a felony, punishable by up to 3 years in prison. The proposed legislation we're announcing today would reclassify simple possession of 10 grams of less of any drug for personal use as a misdemeanor. The maximum prison term for violations of the statute would be adjusted to correspond with a misdemeanor offense, not more than 2 years in prison, with jurisdiction in the Superior Court, and the Attorney General's Office will continue to handle those cases. I've been both a state and federal prosecutor for over 15 years. As an assistant district attorney at the Manhattan DA's office and as an assistant United States attorney, I handled both misdemeanor and felony drug cases more than I can count. Some of them were simple possession cases. Some of them were cases that in New York were considered misdemeanors, but here in Rhode Island would be treated as felonies under state law as it currently exists. And some were extremely serious drug trafficking offenses. When I was an assistant U.S. attorney, I've handled many wiretap investigations that involved kilo quantities of heroin, cocaine, and fentanyl. I've also handled cases that involved pill mills and, unfortunately, physicians who were handing out opiates like candy, and as a result, many people became addicted on these drugs and then later moved on from these opioids to heroin and fentanyl. I've spoken with women who were trafficked in order to support their habit. I've spoken with parents and children who became hooked on pills and then became addicted to drugs. And those experiences have taught me that there is actually a substantial difference between those who traffic in drugs and those who possess them because they are fueled by addiction. Drug traffickers deserve our maximum prosecutorial efforts. They are the ones fueling addiction and preying on that addiction. And this office has no tolerance for them, and I works hard to identify them and bring them to justice. If you're a drug dealer, this proposed legislation does not protect you. Just the opposite. It helps us focus our law enforcement resources on the dealers. If you deal drugs in any amount, the law remains the same. You're a drug dealer and a felon, and the Attorney General's office will prosecute you as one. If you possess over 10 grams of a drug, the law remains the same. You will still be charged with a felony. If you possess under 10 grams of drugs and your intent is to distribute them to others, the law remains the same. You will be prosecuted as a felon and as a drug dealer. But those individuals who simply possess drugs, who are addicted and cannot escape, at least not yet, the cycle of addiction, are different, and they should be treated differently under the law and by law enforcement. People who simply possess small amounts to use themselves, in this office's view, that is not felonious conduct, and it should not be prosecuted and punished as such. Why is this distinction so critical? All of us know that felony convictions create serious obstacles for people as they try to re-enter society, find work, and support their children and their families. They carry important collateral consequences as well. By lifting this barrier to successful re-entry, we're removing a barrier to long-term recovery. To some, this may seem very forward-leaning, but this trail has been blazed by others. Many other states and most of our neighbors in the Northeast already view simple possession of drugs as non-felony conduct. As you've already heard, some states, at least one state, Oregon, has gone even farther. The world has changed in the past several decades, and we have come to learn that drug addiction is really a public health problem. It is not so much a criminal justice problem. And we need to be smart about how we handle this issue. And that is why this office is proposing S-188, and I appreciate your support of this bill. Thank you very much, Senator.
Do any committee members have any questions or comments for Ms. Goldstein? Yes, Senator Archambault.
Thank you. I really appreciate Ms. Goldstein's testimony and her experience in the area. And I will say I've spent my entire career dealing with cases from a defense perspective where people fall into this category. And then, unfortunately, they're not given the doorway towards healing the issue. It's about punishing them and getting the pound of flesh. I was thinking as you were talking, Ms. Goldstein, about your experience and how this is overdue. About probably 35 years ago, in my undergrad, American University, there was a professor there. I can't remember his name now, but he was a pretty renowned author, and he wrote about this. He had studied the model of how they recover in England at the time. England was out ahead of the United States and on how they looked at opioid addiction and how they got people into therapeutic models and tried to heal them so they wouldn't be recidivists and resort to criminal activity. It was very forward thinking, but it was also, somewhat revolutionary at the time in the U.S. And, I applaud Attorney General Noronha on this. I remember he was just throwing the idea around, and I think it's great. I don't think we should get caught up on the labels of misdemeanor versus felony as an impediment. I think we should look at it more for all the reasons that you just stated as a doorway to getting people off drugs and helping them to have an opportunity. And by the way, we're already doing that with the diversion program. Senator Burke's brother, Magistrate Burke, was instrumental in helping to get that off the ground, and that's a really good program. It helps people to do that now. But this would codify it. This would put it in law where we can have it as a defined option. And I don't see a con with it. I'm curious if anybody's going to speak against it tonight, but I don't see any cons. But I want to tell you, I really appreciate your testimony and all of your dedication and passion to this. Thank you.
Thank you, Senator Archambault. Any other questions or comments from committee members? Seeing none at this time, thank you so much for joining us this evening and for your testimony.
Thank you very much. Thank you.
Next, we have Senate Bill number 65. We have public testimony from Nicole Camella. Welcome to the committee, Ms. Camella. You may proceed with your testimony.
Thank you, Senator. Good evening, everyone, and thank you to the Senate Committee for your attention. My name is Nicole Camella, and I'm a medical student at the Warren Alpert Medical School, and I'm from Providence, Rhode Island. I would like to voice my support of Senate Bill 65 by Senator Miller, which proposes to exclude the possession of buprenorphine, which is used for patients with opioid use disorder, from those controlled substances that can result in criminal penalties. I would like to share with you this past school year that I had the opportunity to get involved in addiction medicine in Rhode Island and work with many patients in my community who struggle with addiction, many of whom also face other struggles such as other serious health conditions and housing and food insecurity. I have seen how the opioid crisis with the onset of the COVID-19 pandemic has undoubtedly been devastating. With isolation and lack of access to care, we have seen many patients unable to get treatment and die from overdose. One of the patients I heard from had opioid use disorder, and she shared with me her struggles with addiction. She shared a heartbreaking story of her partner, who she relied heavily on for support, getting arrested and jailed for carrying buprenorphine. This arrest destabilized her health and negatively impacted her partner, who also struggled with substance use disorder. As a medical student, seeing patients become at high risk for overdose due to an arrest based on the possession of a literal medical treatment against opioid use disorder amidst the opioid crisis is extremely frustrating. I and many of my fellow peers and colleagues see the situation play out again and again. One of the reasons for the continued opioid crisis in Rhode Island and across the country is lack of access to treatment. So it's difficult to see such a feasible, reliable, and safe treatment such as buprenorphine be subject to legal repercussions. So thank you all for your time.
Thank you very much for your testimony, Ms. Camella. Any questions or comments from committee members? Seeing none at this time, thank you for your testimony.
Take care.
Next up, I believe, is Catherine Itasi.
Yes.
Yes.
Itasi.
Welcome to the committee. I believe you're from the ACLU of Rhode Island, and you are speaking on Senate Bill number 65, and I believe there are three others, 257, 502, and 315. If you could please state the number you're testifying on first, and then your testimony, please.
Yes, thank you, Madam Chairwoman and the honorable members of the committee. I will try not to repeat too many of the comments that have already been made tonight. I am representing the Rhode Island ACLU, and we do strongly support the decriminalization of possession of controlled substances for all of the reasons that were iterated tonight. As Senator Mack already noted, countries like Portugal that have decriminalized drug possession have seen tremendous successes, including fewer overdose deaths, fewer HIV infections, decreased number of substance abuse issues, and an increased uptake in treatment. As it pertains to Bill 65, I believe Burlington has decriminalized Suboxone and has seen a large reduction in their number of overdose deaths. And pertaining to S-188, while we do support the idea of decriminalizing the possession, we do believe that it's a bit arbitrary to cap it at 10 grams or less. I believe Ms. McKee already noted that some preliminary research has found 40% of Rhode Islanders arrested for substances are arrested within the 10 to 28 gram range. So we would strongly encourage that the decriminalization is for possession of 28 grams or less, not 10 grams or less. I am also representing the ACLU in the bail reform bill, which I believe is S-315. Yes. As Senator Quesada already mentioned, it acts pretrial detention tends to act as a punitive mechanism for those of lower socioeconomic status. And these are usually pertaining to nonviolent offenses, these misdemeanors. You can lose your job, you can lose custody of your children, you can lose your housing, and many have been found to plead guilty even if they're not guilty of the offense. They find that it's easier to just plead and get out of jail faster. And I would note to Senator Rogers' concern, this is about bail and not an actual conviction. So at this stage of pretrial detention, these individuals are still presumed innocent and are constitutionally declared innocent until proven guilty. Some can fall behind in school. There's been many studies that show that it's disproportionately affecting persons of color. Black men received 35% higher bail amounts than white men. Latinos received 19% higher bail amounts than white males. And it should be noted that if you are pre-trial detention after just 3 days of being in jail is shown to increase the defendant's risk of rearrest upon release. So it almost has a criminogenic effect to it. People can miss their medications or mental health treatment while awaiting their trial. 20% of jail inmates have a serious mental illness, and only 11% of jailed inmates with substance abuse issues are receiving any treatment at the time that they're incarcerated. It should be noted that 60% of people in the United States in jails have yet to be convicted of a crime. As I believe we noted in written testimony submitted to the committee, studies in New Jersey and D.C., where there has been bail reform, showed similar or better rates of appearing for trial than those before their reforms. And with New Jersey, they had a 20% reduction in their jail population. And I would also note to Senator Rogers' concern that according to the Pretrial Justice Institute, raising $400 for an emergency would be difficult for almost half of all Americans. So it is a matter of even getting that few $100s to pay the bail bondsman. It was studied in Harris County, Texas, the third largest county in the United States, that those who were subjected to pretrial detention were more likely to reoffend, 25% more likely to plead guilty, 43% more likely to be sentenced to jail time, and receive jail sentences twice as long as those released before trial. As it pertains to S-257, which would amend the penalties for larceny and shoplifting, we support this bill. I was once, when I went by the name Catherine Godin, practiced criminal defense, and I was once court appointed to represent a defendant who had stolen or was accused of stealing a whiteout pen. So I would suggest that for these lower tiered offenses, we can really conserve some of our resources in the state. We fully support having a tiered system of punishment and adjusting these tiered amounts each year to reflect the rate of inflation. Doing so would reduce the number of individuals incarcerated for low-level offenses. It would lessen the burden on our correctional institutions by imposing shorter sentences and would spare more individuals from the collateral consequences of a criminal conviction. The felony larceny threshold amount was last amended 9 years ago, and I believe as it pertains to the shoplifting statute, the penalties currently in place have remained in place for the last 30 years. It should also be noted that it is unlikely that implementing these amendments would encourage more larcenies or shoplifting incidents to occur. The Pew Charitable Trust found in April 2017 that in the 30 states that raised their felony theft threshold, downward trends in these crimes rates
continued without interruption and roughly had the same amount of decrease as the 20 states that did not change their theft thresholds.
Thank you.
And I believe, lastly, we oppose Bill S-502 on the child erotica bill. The Supreme Court found that virtual child pornography being banned was unconstitutionally overbroad in Ashcroft v. Free Speech Coalition, 535 U.S. 234. As they note, it would actually tend to criminalize things like movies. The movie American Beauty would constitute a criminalization under this bill. In criminalizing these virtual images of child pornography, it's not actually going towards attacking the real significant issue, which is obviously the actual child abuse that occurs when there's production of or distribution of child pornography. When it's a virtually created image, it's actually prohibiting speech that the United States Supreme Court found records no crime and creates no victim. They found that it's not intrinsically related to child sexual abuse. What they were concerned with was actual child pornography, which creates a permanent record of the child abuse and perpetuates the economy of child pornography production and distribution. As the court found in Ashcroft, the mere tendency of speech to encourage unlawful acts is not a sufficient reason for banning it, absent some direct connection. And in Ashcroft, they found no more than a remote connection between virtual child erotica and actual child abuse. We would also note that the bill 502 would depend upon whether the image was used for sexual gratification. So if one person possessed it and did not possess it for the purpose of sexual gratification, and another person possessed that same image with a different intent, it would be treated differently. We already have very strong child pornography laws in place with stiff penalties, so we would strongly oppose the implementation of S-502.
Thank you.
Thank you.
Any committee members have any questions or comments for this witness? Seeing none at this time, thank you for joining us this evening.
Thank you very much.
Next, we're going to move to Senate Bill 503 by Senator Oyer on behalf of the Attorney General's Office. First witness on the line is Lisa Peterson. Good evening, Ms. Peterson. If you could just let us know what organization you're representing this evening, and then
Absolutely,
you may proceed.
I'm here. Sure. I'm here both as Chief Operating Officer at VICTA, which is an agency providing substance use, mental health, and medical services, and as the co-chair of the Super PAC, Substance Use Prevention, Education, and Recovery PAC. So thank you for taking the time and for hearing me tonight. I'm here in support with both my hats on for S0065 to decriminalize possession of buprenorphine without a prescription. At VICTA, we are fortunate to see firsthand the life-saving effects of buprenorphine every day. In the 2 short years that we have been open, we've treated over 300 people with this medication and seen countless lives improved as a result. Over the past few years, Rhode Island's made significant progress with increasing the accessibility of this medication for those who need it, but for too many individuals, barriers to care still exist. These might be things like lack of insurance coverage, prior negative experiences with the treatment system, fear and discrimination around opioid use disorder from a number of providers, and difficulty getting to or keeping appointments because of the nature of their lives. As a result, many people seek to obtain this medication from friends and other people in order to treat their symptoms of withdrawal or to manage cravings without returning to use of an illicit opioid. Given the nature of the drug supply currently and the persistent and increasing overdose crisis, this is a much safer choice until they're able to consistently access care. I myself have gotten a call after hours from a former client who wanted to come back to treatment and asked if he should try to obtain buprenorphine off the street until he could return to services. Of course, I made it clear that I could not officially or formally recommend this, but I also let him know that he needed to do whatever he needed to do so that he didn't pick up a potentially deadly dose of opioids. So for me, I think it's time to start putting our policy where our theory is and treating substance use disorder as a health concern and ending the penalties that further impede individuals' efforts to establish and maintain recovery. Decriminalizing buprenorphine frees individuals, and it frees up resources that can be more effectively reallocated as we all work to improve the health and safety of Rhode Islanders. I would like to thank Senator Miller, yourself, Madam Chairwoman, and all the co-sponsors for putting forth this important bill. And I'd like to thank the committee for taking time to read and listen to all the related testimony. I urge you to pass S0065 so we can protect Rhode Islanders who are living with opioid use disorder.
Thank you very much, Ms. Peterson. Are there any questions for this witness from any members of the committee? Hearing none. Thank you very much for your testimony.
Thank you.
Thank you. Our next witness is Ryan Holt with the Attorney General's Office. Hi, Ryan.
Hi, Senator.
How are you? Welcome to the committee.
Thank you. Thank you. Good to be here.
Yes, excellent. You may proceed, please. Go ahead.
Thank you, Senator. And I should say, Mr. Chairman. And good afternoon, ladies and gentlemen. This is Ryan Holt, the Director of Legislative Affairs for Attorney General Morona. Speaking first in favor of Senate Bill 503 that Chair Oyer was kind enough to introduce on behalf of the AG. We're always excited to work with Senator Oyer on legislation, and this, as Senator Oyer said earlier, certainly advances the hard work that the Senate has been doing for years in the field of criminal justice reform. And we think that this bill, has two simple but very impactful changes that will advance our shared goals here. As Senator Oyer mentioned earlier, expungement access and awareness has been a major priority of the Attorney General, who in pre-COVID times had held a few different expungement clinics throughout the state, which, as Senator Oyer mentioned, generated a lot of interest. And we really look forward to revamping that program once we're able to gather again in person. When COVID hit, we then developed an online application process as well for folks to be able to have us take a look and help them assess their eligibility. As such, combining both our in-person and virtual forums, we have processed over 570 applications so far, with a little over half of those applicants being made aware that at least part of their record currently, under current law, qualifies to be expunged. And as such, this is such an important piece in the reentry puzzle. Opening the door to eligibility for jobs, for educational opportunities, for housing opportunities. And some of the things we learned, as Senator Oyer mentioned, was that, this $100 fee is a real barrier to folks, and it ought to be eliminated as such, because this fee should not stand in the way between someone who would otherwise be eligible to have their record expunged and get back on the road to reentry, clearing their record. And it also does something important by expanding eligibility in the motion to seal. Currently, if you have certain felony convictions on your record, you're only eligible for a motion to seal in certain instances after acquittal at trial. This expands it to all other types of dismissal or non-conviction dispositions, which just seems like common sense to us. So, Chairman, would you mind me to move on to the next bill, or should I take questions on this if they're there?
Oh, thank you for asking. Are there any questions on this bill for Mr. Holt? Hearing none, thank you. Why don't you move on to the next one? Thanks for asking.
Thank you, Chairman. I appreciate that. And this would be Senate Bill 393, and not testifying either for or against, just wanted to make the committee aware of a few thoughts related to background check legislation. As I imagine you'd all be aware, the General Assembly, as they do every year, are considering a number of background check related bills. And, you know, all of these bills, when being considered, we just need to be mindful of assessing what impact, not just this bill, but any background check bill that the legislature would pass would have on operations at our BCI, in our BCI unit, which not only processes national and state background checks, but also security company licenses, gun permits, and is also kind of the first point of contact for folks when they're filing expungement affidavits with the office, as well as getting an appointment with our Consumer Protection Unit if you come in person. You know, current stats, we process about 120 in national background checks a day, 300 state background checks a day, and if you've been to our offices in Cranston, at least back in more normal times, pre-COVID times, folks are able to move pretty quickly through that system. You're not waiting in a very long line. And we'd like to keep it that way because obviously this service is very important to folks getting jobs and the like. So processing, you know, upwards of 500 people on a normal day. And just to note for the committee's benefit, you know, over the last few years, those numbers have steadily increased by about 10 or so % every year, which is fine, but our staffing has not changed. So just want to have folks be aware that when considering background check bills, not just this one, but in the aggregate, you know, potential impact on our operations. Also, you know, while I think, you know, there are some noble pieces in this bill about waiving the fee for folks making under $40,000 a year, I'd like to note that from national background checks, we cannot waive that fee. That is an FBI fee. So that's just something for the committee to be aware of. But finally, when speaking about the FBI, anytime the legislature would pass a bill on national background checks, in order for us to be authorized to run those checks, we do need to vet the language through the FBI. So I would just ask the committee if it would be considering either this version, or I had heard some mention of a potential sub-A, whatever version ends up moving, if so, to please keep us in the loop so we can work with the FBI to vet that language to ensure that if you end up passing a bill, we'd be able to run those checks. So with that, I'll take any questions if you have them.
Thank you very much, Ryan. Are there any questions for Mr. Holt?
Thank you, Chairman.
Many members of the committee, welcome. Hearing none, thank you very much for your testimony. You have a good night.
Thank you. Have a good evening, everybody.
You as well, thank you. Our next caller is Bella Robbins from Coyote, Rhode Island, and we're now on Senate Bill 249. And Ms. Robbins is also going to speak on Senate Bill 604. Good evening, Ms. Robbins.
Yes, this is Bella Robinson. Thank you so much for listening to me this evening. My name is Bella Robinson. I'm the executive director of Coyote, Rhode Island, which is a sex worker rights organization. And I'm here tonight to testify in my support of two bills, Senate Bill 249, which is the sexual assault bill, and Senate Bill 188, which is the bill to reduce drugs under 10 grams to a 2-year misdemeanor. I am a person affected. I've been clean and sober for 15 years. I was sentenced to 3 years and then 5 years in Florida DOC, where I was sexually assaulted by correctional officers at Lowell Correctional Institute, which is now under investigation by DOJ because it's been going on for 20 years. So I got out in June of 2000. I'm still getting over the trauma of my incarceration. I did go to long-term rehab, after I got out of prison. But I can attest that rehab doesn't work until people are ready. So I also tend to wonder, while I totally support the bill, getting some harm reduction is better than none. I don't understand why it's a 2-year misdemeanor, not a 1-year misdemeanor. And I think we need to be really careful between, claiming that drug dealers are bad people and drug users are victims. Because in my addiction, if you were a drug user, you sold drugs so you could afford your drugs, because drugs are expensive. So I don't know how many people this is going to help, but I think it's a step in the right direction. And now I want to go on to the sexual assault bill. So as Senator Bell mentioned, we found out a few years ago there was 35 states where it was legal for a police officer to engage in sex while they have someone detained or in custody. And we chose the word peace officers, so it would include probation officers, correctional officers, police officers. And it's pretty easy to understand when someone's threatening to take you to a jail, you can't truly consent. It's kind of like having a gun held to your head. And we have cases of this across the country that have been reported. Just last year in Ohio, there was a police officer that assaulted and murdered a street-based sex worker, did not have his badge on him, and had years worth of reports from sex workers saying they were exploiting him. I also want to point out that as Coyote has done street outreach in Providence, street-based workers have told us that police officers are threatening them to perform sex acts under threat of arrest. They take them behind abandoned buildings. I think House of Hope has documented the same thing. And I've yet to meet a sex worker in Rhode Island that has been arrested where the police officers did not engage in some kind of sexual conduct before they arrested them. I actually don't think the bill goes far enough, because it only says sexual penetration, as if other forms of sexual assault aren't a big deal, and they're just as traumatizing. But I think that, again, this is a step in the right direction. We think that all citizens, especially women, should have the right to come forward and report crimes, even if those crimes were committed by someone in office. And I also want people to point out, is there any reason that would justify why a peace officer would engage in sex, even if they're off duty, with someone they have if you're supervising my probation, it's obviously not okay. We have sex, even after you're off work. So I would hope that that committee would vote to pass this out of committee, and I'd be glad to answer any questions.
Thank you very much, Mr. Robinson. Are there any questions for this witness from any members of the committee? Hearing none. Thank you very much for your testimony. Appreciate it.
Thank you.
Thank
have
you.
a great night.
You have a nice night as well. Our next caller is Shana Wells. Good evening, Ms. Wells.
Hi.
Hi, welcome to the committee. You may proceed.
Thank you very much.
Thank you.
Hi, my name is Shauna Wells. I'm a resident of West Warwick, Senator Burke's district, and I'm testifying in support of S249. I'd like to thank Senator Quesada for co-sponsoring this bill. Everyone in the United States has civil rights. Citizens, immigrants, undocumented immigrants, foreign travelers, and even those accused of a crime have civil rights. We all have the right to be free from excessive force by peace officers, granted to us by the 4th and 14th Amendments to the U.S. Constitution. When officers abuse their power or exceed the limits of their authority to deprive a person of his or her civil rights, this is police misconduct. Rape and sexual assault are violent felonies. When perpetrated by peace officers in positions of power over those in their control, they deprive the victim of autonomy, agency, and consent, along with harming them physically and psychologically. Peace officers swear an oath to protect and defend and uphold the laws of our state. There is never, under any circumstance, a time where rape or sexual assault is legal. It's violence, pure and simple. And it's the height of hypocrisy for police to be above the laws they use to deprive others of their liberty. They don't get to decide who's deserving of safety and protection, even when that person is remanded to their custody. Those who are detained or under arrest are legally incapable of consenting to sexual acts with peace officers who hold enormous power over them. This bill makes clear what should be common sense, but clearly isn't, that peace officers aren't above the laws they enforce and will be held to account when they break them. Please support S-249 and make clear that peace officers will face the consequences of their criminal behavior just as all rapists should. Thank you.
Thank you very much, Ms. Wells. Any questions for Ms. Wells from any members of the committee? Hearing none, thank you for your call. You have a nice evening.
Thank you. Same to you.
You're welcome. Our next caller is Maura Kitterick, testifying on S-249 and also on S-604. Good evening, Ms. Kitterick.
Hi.
Hi, good evening. You may proceed.
Thank you. Hello, my name is Mara. I'm 15 years old, and I am testifying on behalf of myself in support of Bills 604 and 249. These bills are fairly straightforward, so I'll make this brief. Starting off with Bill 604, this act would essentially make drug possession a civil offense rather than a felony. So rather than the penalty for this offense be jail time, the penalty would be a fine, drug counseling, community service. I strongly believe that if we want to prevent people from committing the same crime again, we need to take positive action rather than just focusing on punishment. By requiring drug counseling and community service, you are doing just that, thus benefiting all parties. Moving on to Bill 249, this act would prevent peace officers from having sex with people in their custody. Honestly, it astounds me that this has yet to be made illegal, so now is the perfect time to legalize it by supporting Bill 249. Peace officers have power and authority over those in their custody, so it is completely unethical that officers having sex with those in their custody is still legal. I am terrified to think that if I or someone I know, or even someone I don't know, was in custody, they could be pressured into having sex with someone they do not want to because they are afraid of what the officer could do if they disagree. So, in order to protect those who do not have the power in this situation, we must make it illegal for the action to take place in the first place. You must pass Bill 249. Thank you all for your time, and please support Bills 204 and 249.
Thank you very much, Ms. Kitterick. Are there any questions for this witness from any members of the committee? Hearing none, thank you very much for your testimony. You have a nice evening.
Thank you. You too.
Thank you. Our next witness is Gabrielle Monroe with Survivor Siblings. Good evening, Ms. Monroe.
Hi there.
Hi, welcome to the committee. You may proceed.
Hi, my name is Gabrielle Monroe, she, her, co-founder of Survivor Siblings. In 2004, I was arrested for the non-violent victimless crime of prostitution. During my arrest process, I was cuffed sitting on the bed. I refused to talk to the officers, and while I sat there, they kept trying to question me. Eventually, they got bored and started to talk about the microphone that had fallen and alerted me to the fact that I had been caught up in a sting. I sat on the bed and I listened to the officers. The undercover officer that had arrested the alleged prostitute before me had said, in his words, she was so fucked up that her legs were everywhere. This officer then walked over to the end table where the microphone was taped at and banged his hand on it, showing how her legs were everywhere. And the officer continued to say, as he was doing her. I'm 24 years old, cuffed on a bed, thinking, oh my gosh, did I just avoid being raped by a police officer? Nobody deserves to be raped by a police officer or anybody else who has a position of power. Please support this bill. Thank you for your time.
Thank you, Ms. Monroe. Are there any questions for this witness from any member of the committee? Thank you very much. You have a nice evening. Our next caller is Miko Lernet, or Lenert. I apologize for the mispronunciation. Good evening. Miko Lenert? We can stand by for 1 minute. He's on. Good evening. Miko Lenert?
Yep.
Yes, welcome to the committee. You're here to talk on S-249 and also S-604. You may proceed.
Thank you.
So I'm going to start with 249 about sexual assault relating to criminal offenses. And I'm just really surprised that there isn't a bill covering this already. There's no reason that this should ever be legal or not have consequences. And I don't really see why it wouldn't get passed. I think it's just kind of common sense that you can't assault someone who's in your custody as a police officer. That just doesn't make sense. And I also appreciate the 3-year punishment time that they put, because I think that that's reasonable. It's not overzealous, but you need consequences for things like that. So I really appreciate this bill, and I think that there's no reason that this shouldn't already be in place. And then for 604 about controlled substances, I was looking at the bill, and it said that before this, you could get fined as much as $5,000 for possessing any drug besides marijuana. And I understand that people are concerned about drug use, but I just don't think it's a reasonable amount of money. And fining people more and punishing people more harshly isn't going to stop them from using drugs. It just puts them in a position where they can't pay, and it's just hurting people who are already hurting. And I think that if we're really concerned about drug use, then we need better education and more public resources to help the people with the problems they're using drugs to solve, not fining them several $1,000s. So yeah, I support both of these bills, and thank you for your time.
Thank you very much, Ms. Leonard. Are there any questions for this witness from any members of the committee? Hearing none, thank you very much.
Thank you.
Thank you. Okay, if we could just stand by for 1 second. Thank you. Our next caller is Mstante with SWOP behind bars / Coyote. Good evening, Ms. Dante.
Hello. Thank you
Yes.
for returning the call.
Of course. Welcome to the committee. You may proceed.
Hello. Then thank you to the committee for allowing for me to offer comment. I am affiliated with Swap Behind Bars and also with Coyote since 2016. We've helped on numerous research projects and have worked together in efforts to address stigma and de-escalate violence. And so the call is simply to say that we definitely support any bill that takes on the issue of custodial assault and sexual servicing of any type of law enforcement or peace officer.
Thank you very much. I appreciate your testimony. Anyone else in the committee want to ask any questions or have a question for this witness? Hearing none. Thank you very much. You have a nice evening.
Thank you, and to you all also.
Thank you. Our next caller is Nicolette Bernardi. Good evening, Ms. Bernardi. Good evening. Hello, Ms. Bernardi.
Hello, can you hear me?
Oh, yes, we can. Welcome to the committee, and you may proceed.
Hi, I'd like to testify in support of the bill.
Hi, yes, Ms. Bernardi, you may proceed. We can hear you. Go ahead, please. Ms. Bernardi? Ms. Bernardi, the call dropped. If you can hear this, feel free to call back and we'll put you back in. Your call dropped. Our next caller is Isaiah Tobias Lee, or Tobias Lee, testifying on 249 and Senate 315. No? Okay, he can't, so we're going to pass. Our next caller will be Randall Rose, testifying on this bill, S-249, and also S-502 and S-189. If we could stand by for 1 second, we'll see if we can get him. Thank you. Randall?
Thank you, Mr. Chair and members of the committee.
welcome to the committee.
So I'm sure I'm not the only one in support of Senate Bill 249. I think this is a really important bill on sexual assault. It's because unfortunately our laws are not crystal clear that that sex while someone is in police custody is a crime. A police officer who has sex with someone in custody can claim it was consent, and this bill just makes a clear delineation and makes clear that unless it's proved that unless it's proved to the contrary, the bill just makes a clear delineation and just makes it completely clear that police are and other people in the criminal justice system are never to have sex with someone in custody unless it results can be proven that it resulted from force or coercion by the other person. So I think this is a very good bill. It's not hard to comply with. It just means that that police officers and others have to refrain from sex with those in custody. And the vast majority of times when that kind of sex happens, it is coerced anyway. So this is a good bill, and it's a good bill, and I hope this is passed. I know this is not the first year it's come up. It's been up before. I don't understand why we haven't passed it already. But the vast majority of police officers do not do this, do not have sex with people in custody. But because it does happen sometimes, people should not have to be worried about sexual assaults by police officers while they're in custody. So I'm in support of the bill. Thank you.
Thank you very much, Mr. Rose. Are there any questions from any members of the committee for Mr. Rose? Hearing none, thank you, Randall, and you have a nice night.
Thank you.
Our next bill is S-502, and we have Lieutenant Eric Yell from the Rhode Island State Police to talk in support. Lieutenant?
Yes.
Yes, good evening. Welcome to the committee. You're here to speak on 502, and you may proceed.
Ready to go?
Yes, Lieutenant, please. Go ahead. Thank you.
All right, thank you.
Welcome.
Good evening, Chairwoman Coyne and members of the Senate Judiciary Committee. Thank you, Senator Burke, for sponsoring this bill. I sincerely believe this legislation is necessary to protect the children of Rhode Island, and I'm confident that when I am done testifying, you will feel the same way. My name is Eric Yell. I'm a lieutenant with the Rhode Island State Police and serve as the officer in charge of the Computer Crimes Unit. For approximately 11 years, I've been part of the Internet Crimes Against Children Task Force and presently serve as a task force commander for the state of Rhode Island. Currently, it is illegal in Rhode Island to possess, transfer, or produce child pornography under Rhode Island General Law 1191.3. However, it is not illegal to possess, transfer, or produce child erotica. Child erotica involves prepubescent children dressed seductively, oftentimes wearing lingerie or string bikinis, and posing in a sexual and salacious manner. Please do not let the term erotica mislead you. These images have no artistic or literary connotations as the term may indicate. These are child sexual abuse images. These pictures and videos serve no legitimate purpose and are used solely for sexual gratification. These files are disturbing and clearly exploit the children who are the subject of the images and videos. One look into their eyes, and you cannot help but see a vapid, lifeless soul instead of a vivacious, innocent child. But I digress, because these images are not meant for you to look into their eyes. They are possessed and viewed by pedophiles for sexual arousal. Unfortunately, they are still legal in Rhode Island. Several series or collections of child erotica have been identified by the National Center for Missing and Exploited Children, or NCMEC, and are associated with identified victims in known or confirmed files of child pornography. The ICAC task force often receives cyber tips from NCMEC that are initiated because someone possessed or transferred images of child erotica. Unfortunately, there is no legal recourse in Rhode Island for the task force to investigate these reports. Without a crime, detectives cannot initiate legal process such as an administrative subpoena or a search warrant to identify the person producing, possessing, or sharing these files of child exploitation and sexual abuse. If Rhode Island passed a child erotica statute, it would allow law enforcement to properly investigate such cyber tips and identify pedophiles who are potential hands-on offenders. These subjects can be known registered sex offenders, but they can also be your neighbor, your child's teacher, their coach, or another person of trust within our community. More importantly, it will help us identify victims and prevent future exploitation and sexual abuse of our children. To further clarify, I am not describing suggestive selfies that teenagers may send to one another, nor am I talking about parents taking pictures of their toddlers in the tub, running through a sprinkler, or playing at the beach. I am also not talking about drawings or animations. When you see child erotica, you know exactly what it is and exactly what purpose it serves. Last year, I testified in person before the House Judiciary Committee. I brought a portfolio containing images of child erotica so legislators could clearly understand what words truly cannot express. Some legislators turned away in disgust, and others didn't look at the images after seeing the reactions of the colleagues. ACLU Executive Director Steve Brown testified against the bill, but refused to look at the images. Unfortunately, the legislative session was stopped a few days later due to COVID-19 pandemic. But I am pleased to report that Representative Norrie resurrected this worthy cause, and I testified again before the House Judiciary Committee a few weeks ago. They say a picture is worth 1,000 words. In the case of child erotica, a picture is worth 1,000,000 words. As I testify remotely today, I cannot provide examples that you need to see to completely understand this issue. If any member of this committee, the Senate, or the legislature as a whole has any doubts or concerns regarding this legislation, I invite them to visit our office where I can personally show them the amazing work this task force does, the significant difference this legislation can make protecting our children. Child erotica is not an outlier. We deal with this situation all the time. For example, this week we received several cyber tips that contain child erotica from the National Center for Missing and Exploited Children. They were closed without an investigation. This past Friday, we executed a residential search warrant for a suspect that was sharing tens of thousands of files of child erotica. Fortunately, he also shared some files of child pornography, which allowed us to serve legal process, ultimately identifying the internet connection that was used to share the files. The suspect was identified and arrested. So far, our preliminary investigation has identified approximately 105,000 files of child sexual abuse material, most of which was child erotica. We often conduct sex offender compliance checks, assisting probation and parole. We frequently find child erotica on their personal devices, but we cannot charge them with the crime. In one recent case, the suspect had been investigated for sexually related crimes involving children for 20 years. They had previously been arrested for child pornography, stalking, as well as disorderly conduct for filming young girls at various athletic events. For various reasons, those charges were dismissed. In 2018, the suspect was arrested again for child pornography and finally required to register as a sex offender. During a probation compliance check in 2019, detectives observed tens of thousands of child erotica files, but again, the offender could not be charged with the crime. Fortunately, during a subsequent check in 2020, detectives located child pornography, and the offender is now incarcerated. In closing, the passage of a child erotica statute is critical to protecting our children and identifying those who seek to exploit them. It is society's responsibility It is our responsibility to protect our children from being sexually exploited and abused. The children portrayed in these child erotica images and videos are affected physically, socially, and psychologically for their entire life. This is our opportunity to make a difference. Thank you again, Senator Burke, for sponsoring this legislation. I thank you all for your time and consideration, and I ask that you support this important legislation. Thank you.
Thank you, Lieutenant Yell. Do any committee members have any questions of the lieutenant? No questions at this time. Thank you for joining us this evening, and please stay safe.
Thank you.
Thank you. Next up, we have Mr. Carl Kruger. We're moving now to Senate Bill 118. Senate Bill 118 by Senator Acosta. We have Mr. Carl Kruger from the ACLU of Rhode Island. Mr. Kruger, if you want to proceed with your testimony.
Yeah, thank you very much, and thank you to the chair and the members of the committee for having me. I'm an immigration attorney. I've been practicing immigration law for 35 years, but I'm also on the board of directors at the ACLU, and I'm here to express the Rhode Island affiliates' support for S-118. Rhode Island, like most jurisdictions, has distinguished between misdemeanors and felonies based on the amount of jail time that is potentially going to be a sentence in a particular criminal matter. Rhode Island says that a misdemeanor is a crime that can be punished by up to a year in jail. And if the crime can be punished by over a year, it's a felony. The reason why this S-118 is so important is because federal immigration law straddles that line one day on the wrong side of things. For example, an individual can become deportable regardless of any of his equities if he's been convicted of certain crimes that are punishable by a year or more. So that would encompass most misdemeanors. Similarly, and even more harshly, if an individual is convicted of a crime and is sentenced to a year or more, in very, very many common situations, that individual, again, becomes deportable from the United States. So, again, misdemeanors are swept up into this because of the federal law's definition of what is a deportable offense. Tweaking this law, moving the maximum sentence for a misdemeanor down to 364 days, down from 365, will have the immediate effect of eliminating the possibility that non-citizens can be subject to deportation for these relatively minor transgressions. This tweaking has been done in a number of other states, and the Rhode Island affiliate of the ACLU hopes that the Senate will see fit to join that group and eliminate this potential problem for non-citizens for, again, relatively minor transgressions.
Thank you, Mr. Kruger.
I thank you very much for having me.
Thank you, Mr. Kruger. Senator Archambault.
Thank you very much, Madam Chair. Carl, I don't know if you remember, or if you, first of all, I don't know if you heard the earlier testimony when Senator Acosta explained his bill, and then I made some comments about the impacts of immigration in the practice on people being deported. But many, many years ago, before you were with the ACLU, and I didn't know you were with them, I went down to see you on a case where I was trying to keep somebody from being deported, and you were great. You were very helpful. You gave your time to me. I was a young lawyer, didn't know what I was doing, but I was on this mission. And you were somewhere down there, Roger Williams Zoo. You were somewhere down in Providence, if I'm remembering correctly. I could swear it was you, and I kept calling you, and you were giving me insights and helping me. Do I have the right man? I think I do.
I have been working with a place called the International Institute, and it's now called the Dorcas International Institute on Elmwood Avenue for 33 years now.
It was you.
Yeah, very likely it was me. So I appreciate the kind words, and again, this is what we, in the profession, we do try to help out each other, and the business is kind of complicated stuff, but I'm
Okay.
happy that I was able to help you, and I'm thank you for the kind words. I'm glad you remembered me.
Yeah, of course. Thank you very much. Thanks for testifying. Thank you, Madam Chair.
Thank you, Senator. Any other questions of committee members? Seeing none, our next witness is David Valise from Rhode Island Interfaith Coalition to Reduce Poverty. Welcome to the committee, Mr. Valise. You may begin your testimony.
Thank you, Chairperson, and thank you, committee members, for allowing me to be with you tonight. My name is David Valise. I am the director of the Rhode Island Interfaith Coalition to Reduce Poverty, and we would like to voice our support for Senate Bill 118, which would change the definition of a misdemeanor from 1 year to 364 days. This minor change of 1 day would have a major impact on immigrant families in Rhode Island. By making a 1-day change for the definition of misdemeanor, this bill would protect hundreds of Rhode Islanders from these unnecessary harsh immigration consequences. This bill would not change the prosecutor's ability to charge people with felonies for larger offenses, but instead would keep minor offenders like lawful permanent residents who are charged with crimes that require no jail time from facing deportation and being taken from their families. We don't believe in unfair and disproportionate consequences and tearing families apart for simple mistakes. We believe in redemption and that everyone has a chance to change their path and learn from their past. If I may share a piece of our sacred text, it says, "Speak up for those who cannot speak for themselves, for the rights of all who are destitute. Speak up and judge fairly, defend the rights of the poor and needy." The Rhode Island Interfaith Coalition to Reduce Poverty is a coalition of faith leaders, advocates throughout Rhode Island who are working to end poverty and fight inequality. Our collective faiths are united in the belief that we must fight injustice and help those in need. Thank you for your time, for supporting this legislation, and for helping immigrant families in Rhode Island.
Thank you, Mr. Valise. Any questions from committee members? Seeing none at this time, thank you so much for joining us this evening.
Thank you.
Next, we move to Senate Bill 604 by Senator Mack. I believe it's Ariana Cunha on the phone. Welcome to the committee. Ms. Cunha, you may begin your testimony.
Hello, can you hear me?
Yes, we can.
Hi, my name is Ariana. I am 16 years old, and I am here in support, on behalf of myself, in support of both Bills 249 and 604. These are bills on sexual assault and controlled substances. A little bit of context on myself that does matter. I am hub coordinator of Sunrise Rhode Island Youth. We are one of the biggest youth-led advocacy programs in Rhode Island, and I've talked to my hub, and almost every single one of us support this legislation. Bill 249 is a great piece of legislation that because I didn't even know that was legal before I heard about it, which is insane. My one concern with the bill itself, that because I read it, is that it just includes sexual penetration, and I know that like sexual assault and sexual intercourse can be more than just sexual penetration. So I recommend going back to that and deciding if that was the right wording to put there. Other than that, I fully support the legislation, and I think it's really great. To move on to 604 about controlled substances, I would love to also express support for that one too. I think $100 is an extremely fair fine, also because I know that many people use substances for mental health, and I think an awareness class is a great solution to that. Nothing else major to say. I am just a youth leader here to express support because I think this is great legislation, and I'll be really proud if you guys also support it.
Thank you very much. Thank you for joining us. Let me see if there's anybody who has any questions. Any committee members have any questions of this witness? Seeing none at this time, thank you for joining us.
Thank you.
Just for the committee members, we have two more witnesses scheduled to testify this evening. Next up, we have Senate Bill 605 by Senator Oyer. First up, I believe we have Christine Cunin. Good evening, Ms. Cunin. Could you please state the agency or organization that you're testifying on behalf of?
Yes, thank you, Chairperson Coyne and honorable members of the Senate Judiciary Committee. My name is Christine Canine, and I'm a small business owner and currently serve as a member of the Legislative Committee for the Rhode Island Society of Human Resource Management, Rhode Island SHRM, and that is who I am testifying on behalf of this evening. Rhode Island SHRM is a volunteer organization representing more than 800 human resource professionals throughout the state of Rhode Island, and our members are a true cross-section of the Rhode Island economy. Our mission is to serve the needs of human resource professionals, many of whom are charged by their employers to screen applicants for the purpose of hiring the person best suited for their companies. We appreciate the opportunity to offer our professional insight and to let you know that we do oppose Senate Bill 605. I would like to be clear, though, that our opposition to this bill is not an opposition to providing opportunities for workers with criminal backgrounds. In fact, Rhode Island SHRM is a signatory to the National SHRM Getting Talent Back to Work pledge, and in doing so, our organization has committed to giving opportunities to qualified people with criminal background deserving of a second chance. However, we do oppose S605 for the following reasons. Number one, the ban the box legislation that came about in 2014, where the question about criminal convictions and have you ever been convicted of a crime has been removed from the initial application. And as Senator Oyer stated in her introduction of the bill, she said, you know, now it's just folks are doing background checks early. But in essence, employers have to get people to work fast. So they're not trying to hold people from jobs. They oftentimes are hiring, multiple people at one time, so they have to run these background checks and get these people through the system to get them ready for training classes. So this not only will be a hindrance for the employers who are trying to move people quickly through, but also for those applicants who will be delayed with that process. We also, had reviewed the Rhode Island Commission for Human Rights website, their annual report, and we haven't seen any non-compliance with that ban the box law that HR professionals have been following. In addition, the EEOC back in 2012 had come out with guidance on the use of criminal records in the hiring process, which employers are required to follow and do follow. So with that, and then also we noticed in the bill that there was wording about directly related conviction. This just seems wrought with issues and lawsuits because how can you directly correlate a conviction to a job? So, for instance, you can have a plumber that could be the best plumber out there, but they're going to go to someone's house and work at their house, and maybe they have assault charges. Again, doesn't make them a bad plumber, right? So those sorts of things in this bill are very concerning. In addition, there's a lot of redundant steps on notification that are already covered under federal law. So just kind of making other regulations and different law changes in Rhode Island on notification to applicants when it is suitably covered under the Fair Credit Reporting Act, which is all highlighted in our written testimony with the sections of the law for your benefit. And then again, we just want to let you know we oppose the law, but not opposed to helping these folks have reentry into the workplace. We stand ready to work with policymakers, maybe thinking of incentivizing employers instead of having more regulations in this area. It would be a win-win for everybody. Maybe take down in D.C., they work with the District of Columbia's Court Services and Offender Supervision Agency and the HR community and local companies to help put people back to work. So some sort of working together like that rather than this regulation would be appreciated. So with that, and on behalf of the Rhode Island SHRM, I thank you for your time today, and I'm happy to take any questions.
Thank you very much, Ms. Cunneen. Any questions from committee members? No questions at this time. Thank you for joining us this evening.
Thank you.
Our last witness this evening is Judy Gutkind. Good evening, Ms. Gutkind. Welcome to Judiciary Committee. Could you please state the agency that you represent before you proceed with your testimony?
Yes, and thank you for allowing me to testify in front of you this evening. I am a Rhode Island resident. I live in the Edgewood neighborhood of Cranston. I work for a company called Creative Services, Inc., which is a consumer reporting agency in Mansfield, Massachusetts, conducting background investigations across the country and beyond. Many of our clients whom are located in the state of Rhode Island. I am also, our company is a member of the Professional Background Screening Association, which is approximately 900 members strong, and I am testifying on behalf of PBSA. We support fair chance opportunities for those who are attempting to matriculate back into the workplace. We support the current Rhode Island ban the box law, which is straightforward and working quite well. We do oppose Senate Bill 605 regarding not starting background investigations until after a conditional offer, which places undue burden on the business community and delays in the hiring process after the initial interview. This bill, if passed, would require background investigations to be done one at a time. There'd be an interview, a decision made, and then the background check would start. This would cause delays in the hiring process and may mean that the conditional offer would need to be rescinded. We also strongly disagree with the requirement that a conviction must be directly related to the position. This could translate into greater liability for businesses due to the unknown and make them more vulnerable to lawsuits. If someone has an offense in one area, they may have them in other areas, and that unknown would create vulnerabilities. The Equal Employment Opportunity Commission has provided guidance to consumer reporting agencies that we already abide by, and it provides for conducting an individual assessment with candidates, which is a fair and established method by which to work through criminal records that surface during a background check, as well as any rehabilitation that has taken place by the ex-offenders. Background screeners are also governed by the Fair Credit Reporting Act, which is a robust consumer protection law. Under the FCRA, consumers have the opportunity to opt in with full disclosure. It provides for transparency throughout the procedure and then the right to know. This bill is overly burdensome, and as a result, you may find small businesses in the state of Rhode Island deciding not to even conduct a background check at all, potentially bringing more harm to the community. With a background investigation, decisions may then be left to a hiring manager who may be biased instead of supportive of second chances for applicants. There are studies who show that that this creates more burden for those applicants where there are unknowns in the process. The existing Rhode Island Ban the Box bill provides applicants with criminal histories a fair chance at employment, and I would ask that you do not complicate that process. Again, we oppose Senate Bill 605, and I thank you for the opportunity to speak before you this evening.
Thank you very much for your testimony. Do we have any questions or comments from committee members? We don't have any questions at this time, but have the committee members can stand by for 1 minute. I believe we have Senator Reptakis on the line.
Hello.
Hi. Is Senator Reptakis there?
No, this is Adi Goldstein.
Oops, wrong number. Sorry.
Okay. All right. Bye-bye.
Thank you. Just if committee members could stand by for 1 minute, please.
They're doing that.
Senator Reptakis, are you on the line?
Yes, Madam Chair. May I be recorded in the affirmative on on all the items?
Yes, you may be recorded in the affirmative on all the votes that we took tonight, and it doesn't affect the outcome of any of the votes.
Correct. Thank you.
And thank you for being present.
Thank you.
Thank you, Senator. With that, we have no other business before us on committee tonight. If I could entertain a motion for adjournment.
Motion to adjourn.
Thank you, Senator Rogers. Second by Senator Oyer. All those in favor, signal aye.
Aye.
Thank you.